Okay, welcome everybody. This is the July 2017 expert phone call, and on our Q&A today we have Allison with AMC Legal, and Allison is going to take us through tons of that legal stuff that just confuses most of us, except people who are brilliant like her, and she's going to help clear up a lot of things that we often wonder about. Welcome, Allison.
Thank you, Michelle. Thank you for having me on the call today.
Yeah, Allison, so glad to have you here, and welcome. Well, I am going to actually give the floor over to Allison and let her start. I think there's a chance at the beginning here where she's going to tell us a little bit about herself. So go for it, Allison.
Thank you, Michelle. Yeah, as you know, my name is Allison, and I own AMC Legal. So I'm an attorney, and I've been practicing on my own in my own business for almost 10 years, but longer than that, about 14 years altogether. And I have been helping business owners like yourself kind of navigate the legal maze of all of the different items that affect your business from a legal standpoint. So there's all kinds of topics that touch a business owner, and I want to go through today some of those topics and kind of demystify some of the things, because I know a lot of it can be overwhelming, and I want to make sure we talk through it. I kind of take away all the myths, the misconceptions, and just go down to what it is that's actually going to be affecting your business and what you need to know. So we're going to go through my PowerPoint today, and these are the topics we're going to be covering. So first and foremost is incorporating, so ways to protect yourself from personal liability, the proper setup of a corporation, and things you need to do annually to keep a company going. We're also going to talk about whether you're incorporated or not. Contracts are a big part of any business, so we're going to be going over some kind of contracts 101. And also, no matter what type of business you do, everyone is going to be touching intellectual property as well. So we're going to go over that. We're going to talk about trademarks and copyrights. And then everyone also, anytime you send an email for your business, we need to be considering the CAN-SPAM Act. So we're going to go over the essentials on that as well. Business succession planning, I'm going to touch on that, but that was probably more something that is more advanced. So if you do have questions on that, you can always call me. And I always wanted to also want to let you know that I do a free consultation. So if you have questions or want to dig deeper into any of these topics or even other topics that I'm not covering today, do know that I do offer a 1-hour free consultation as well. So we're going to talk about personal liability protection. So anytime someone is in business, there's always that potential that something's going to go wrong or there might be some liability. So these are the three ways, kind of the trifecta for really getting yourself protected from personal liability. So we had touched on these. So contracts, incorporating. A third one is insurance. Now, I'm obviously an attorney. I don't do insurance, but it is something that I wanted to mention and we're going to touch on today as well. So business insurance. So this is, like I said, handled with your insurance provider, but you do want to make sure, even if you're incorporated or not incorporated, that you do have business insurance. So I want to make that known. You can get general liability insurance, professional malpractice insurance if you're in a professional type of business like me, and also cyber theft is becoming a big type of insurance that you can start getting now. So anytime you hold client information, their credit cards, social securities, any type of personal information, you want to look at getting a cyber theft addendum or rider to your insurance policy. So those are really good ways that you can talk to your insurance provider about. So let's move on to incorporating. There are many different ways to form a business, right? They're listed here. The United States has been around for a couple of hundred years, and before that, these were brought over from England, and so we have many, many hundreds of years of different types of ways that people have started businesses. So you have the sole proprietorship, general partnership, limited partnership, limited liability partnership, the C Corp, the S Corp, and the LLC. So these are, I know, are very, very confusing to people. What on earth is the difference between these? So let's go over the first four I'm going to group together because there really is little or no liability protection when you have these types of businesses. Someone is going to be left kind of holding the bag of liability if you do one of these. So with a sole proprietor, a lot of people out there are under sole proprietorship, and that's perfectly fine. Get your insurance at least to make sure you're covered. And this is just one where a person decides to start up a company. They go to the county, they register it with the county, and they're done. So nothing is separated from you. There's no liability protection. All of the accounting and everything is done through your own Social Security number and your own tax returns. So that's a sole proprietorship. A general partnership is when you have 2 or more people who get together and they say, we're going to work together. The pro to that is, again, you just go, it's simple. You just go to the county, you register it. But the con for doing that is, again, there's no liability protection. But in addition to that, not only are you liable for what you do, you're also liable for what your partner is doing. So you're actually increasing that liability potential. So we generally don't like that one too much. The limited partnership, this is where you're going to have general partners and at least one limited partner. And again, these are not commonly used, but this is one that is allowed in Illinois. So that limited partner is the one who's going to be managing the business, and they still have liability. And then all the general partners are like silent partners, so they're almost like just investors. And then there's a limited liability partnership. So in this one, all partners are going to be liable for their own actions, but they're not going to be liable for their partner's actions. So again, there's still going to be some liability for someone. So the one you see most often, though, is the sole proprietorship. And again, it's simple, it's easy, it's quick, but there's no actual protections for you if you do it that way. And then we're getting to, these are the 3 ways, C Corp, S Corp, and LLC. These are the 3 ways that you can get personal liability protection because you're separating the business from yourself personally. So it's like a legal fiction. Yes, you are the one in the business. Yes, you are the one running it and doing everything. But because you set it up this way through the state, you're separating out that liability. And when we're talking about personal liability, what it is say something goes wrong in the business, someone is harmed, or someone sues you for some reason. But personal liability means is they can get to your personal assets. So they can get to your home, they can get to your car, they may be able to get to your retirement income, any of your assets. When you separate out personal liability from business liability, they can only get to the assets that are listed in that corporation or LLC, and they cannot reach beyond that and get to your personal assets. So that is the benefit of setting up one of these types of businesses. Another benefit is potential tax savings. So let's go through the C Corp, the S Corp, and the LLC. So the C Corp, and you see I put a red cross through here, the pro to this one is that you're going to get liability protection, but the con is that there's a double taxation. So the corporation is charged income tax for any money it makes, and then when it passes that to the owner is paying again on the personal income tax return. So we generally don't do that one. Those are for larger companies, ones you're seeing like traded on the stock index, right? So that's not us, so we cross that one out. So you're left with the S Corp and the LLC. These are the ones that I, as an attorney, work with day to day to help business owners set up their companies. So the S Corp is going to give you that liability protection. The LLC is also going to give you that liability protection. The difference between the two is really how they're going to be taxed. So the S Corp is the only one that gives you a potential income tax savings of about 7.65%. So you can see here with this, the C Corp has the corporation makes a profit, the corporation pays taxes, it's income to the shareholders, and then the shareholders pay taxes again. With the S Corp and the LLC, they're called pass-through entities, which means that the income and the profit passes through to the shareholders or the owners, and then they're only paying their personal income tax on those on their profits that they're making. So this is how the S Corp, kind of laying out as generally as I can, in general, how an S Corp is going to save you money on taxes. And it is all in the wonderful accounting and wonderful things that your CPA or QuickBooks does for you, and all in how you account for how you're taking that money out of the company. So you say you have a profit from your company, about half of that profits, 50%, is going to go to you as salary. On the salary, you're still going to be paying the payroll taxes, so the FICA and Social Security, and then you're paying your personal income tax bracket, whatever that may be. The other half of the profit goes to you as a distribution, and this is the type of income that a shareholder or an owner takes. So the other half goes to you as shareholder as a distribution from the corporation, and that goes to your personal tax return. So because of that, half of the income you're taking, you're not paying that FICA and Social Security on, you're saving about 7.65% in taxes. So these are the differences between the S-Corp and the LLC. Now, I know a lot of people out there think limited liability company. It must be more, it must be safer for liability than an S-Corp because of that in the name, and that's not true. In fact, in my legal opinion, I think the S-Corp is stronger for liability protection because if you especially if you're a single member LLC, you need to make sure you're following all of those paperwork requirements in order to get the liability protection. So just hang with me here. I know this is a lot of details, but we're going to go through all of this, and then we're going to talk about some easier items later on. But because of the S-Corp the S-Corp by state law does require that you do the paperwork. You have to do the annual minutes, and you have to do your annual report, and you have to be, of course, filing income taxes. So if you're doing all those things by law, you're going to get your liability protection from an S-Corp. The LLC statute says you do not have to do those in order to enjoy liability protection. And that's why even some attorneys say that it's better for liability protection. But the courts, when they have been looking at cases and people are sued, they are saying if the LLC did not do those requirements, then you're not treating it separately from yourself, and they are piercing the corporate veil or finding personal liability. So I think with both, you do need to be doing them. You do need to be doing that paperwork. The paperwork is not that difficult, and it's something that you can be done pretty easily, but it is required in order to get that liability protection. But the added benefit is with an S-Corp, you get that 7.65% tax savings. So who doesn't like to keep more money in their pocket rather than giving it to the state and to the federal government? So there are still some instances in which you want to do an LLC, and that is usually if you don't qualify to do the S-Corporation. So for instance, if you're not a U.S. citizen, you wouldn't qualify for the S-Corp status. If you're doing something called passive income, where you're not actively earning your income, maybe you're just sitting back and owning property, maybe you're just earning rental or investment income, then that's kind of a passive activity. You're not actively working on the business to get that money, so you wouldn't qualify for the S-Corp. If you're making changes often, which I have to say in all my 10 years in business, I haven't had one client who says, you know, this year my partner is going to make X amount, and next year we're going to change it, and they're going to keep changing it. That's easier to do with an LLC, but again, it's not something that happens often. Or like I said, the fourth one, property ownership, that's also passive income, and that's why that would be better for an LLC. So let's go through a couple of examples. So we have Jack and Jill. Say they start up a business. They want to start a software development business. This is the type of business I do often. They're both U.S. citizens. They both want to own it 50-50. What do you think? Should they do an S-Corp or should they do an LLC? If they do an LLC, they are going to have that liability protection. However, they're going to have what's called a self-employment tax, which right now in 2017 is 15.3% on all of the income that they earned for that year. So if they had a great year, they earned $100,000, they're going to owe $15,300 in that self-employment tax. So if Jack and Jill take that very same company that they had split 50-50, and they would qualify for an S-Corp because they're doing software development, they're actively working in that business, they would have the same liability protection, but their tax liability would be cut in half. So if they earned $100,000 in that year, they would only own $7,600 in taxes rather than that $15,300. So you can see where the tax savings really does come in by doing the S-Corp. In addition, one thing I wanted to mention, which we might go over later, I don't recall if I have it in the slides, but the S-Corp in Illinois is actually cheaper to set up in Illinois and cheaper for the annual reports than it is for an LLC. So we're going to go over that a little bit later as well. So let's go over the proper setup of a corporation. So this is what I do for all of my clients. I automatically include this. If someone incorporates through me, we're going to do all this and make sure that they're set up right. So, but if you incorporate it on your own, the state would not tell you need to do this. You might not know that you need to do this in order to get that liability protection by incorporating. So you need to do the minutes, resolutions, bylaws for the business, our shareholder operating agreement, if you have a partner, stock certificates, and an indemnification agreement. So that's beyond just filing the articles with the Illinois Secretary of State. So what are minutes? Minutes are they're documents where you're just going to appoint who are the shareholders, who are the members if it's an LLC, who are the directors and officers, when are we going to hold elections. We're approving the bank accounts that are opening because remember, as I said before, if you are getting that liability protection, it's in exchange for you doing this paperwork. So it is an official corporation from the one-person mom-and-pop shop who, sells widgets out of a storefront to a multinational corporation. You all have to do this type of paperwork. Of course, it's going to be much simpler for that one-person company than it would be for the multinational, but the base is still going to be there. The foundation needs to be set up. So board resolutions. Board resolution is again, in the type of clients that I serve, it's a one-page document where it's stating, it's a consent that we're consenting to have this, we're taking this motion or we're taking this action and it's approved by the board of directors. So again, I myself am a small one-person S corporation, and I do have to do these. So if I go and open a bank account, for instance, I, as board member, have to approve of me as president going and opening up a bank account. So we just have to do these documents in order to get that liability protection. So it's some paperwork, but it's a lot that you get in return by having that liability protection as well. So here's just a sample of kind of what a board resolution looks like. So you can plug in your company name and put that in there, and then I type in the resolve, the type of things that you're going to be doing. So under the board resolutions, these are some instances in which you would be doing a board resolution. So signing leases, if you purchase real estate, if you changed officers. The most common one that I do is if a client is borrowing money, signing a lease, if they're signing any type of big contracts like with a bank, or their annual ones that we're doing each year just to elect themselves as president, secretary, treasurer, etc. But I always say, when in doubt, go ahead and do a resolution. You're never going to be dinged because, oops, I did a resolution and I didn't need to. But you could be in trouble if you're not doing any resolutions. So I always say, when in doubt, go ahead and do a resolution. It takes a couple of minutes and you make sure you're covered. So for most company, again, it's going to be a simple signed consent. You don't actually have to hold a meeting. No matter how many people are in a company, you can always waive that meeting and just, if everyone agrees, you just sign the board resolution. And then it's placed in the corporate book. Corporate book is essentially binder where you keep all of this paperwork. So when I incorporate a client, I provide the binder. It has the bylaws, their stock certificates, and the minutes all in there. And we have those board resolutions. So bylaws. These are the rules by which you're going to be running the company. And again, if it's just you, you're going to be, of course, following the rules. Same with me. But they do have to be written out and signed and put in the corporate book, again, so that you can enjoy that liability protection that the state offers. So what's in the bylaws is the role and responsibilities of all the officers and directors. How to remove an officer or director, what if someone resigns, the term and reelection, who can get a loan, who can sign contracts for the business, and what is the purpose of the organization. Shareholder agreement is only needed if there's going to be 2 or more owners. If the owners are married, we do not do one, but it's only if you're having separate people come together to own a company. It is not required, but it's extremely recommended. And I akin this to like a prenup agreement. So if anything goes wrong, or even if the shareholders get along wonderfully, but if something happens, one of them becomes incapacitated, one of them passes away, how is that going to be handled? So it covers the what ifs. So again, like I said, if a shareholder dies or becomes incapacitated, how is that going to be handled in the company? What if a shareholder doesn't participate? I've had that happen to clients before. Everyone comes together, they're all excited about this business, and then one of them, has some personal issues going on. They can't participate in the business anymore. They move. And then what happens? They didn't actually resign or get out of the company, and actually the company still owes them a part of the profits. So we want to make sure that that's covered. When will dividends be paid, or how will they be paid? who owns intellectual property is a big one. Are the shareholders who create that intellectual property, say you have one shareholder is given the task of creating the web design. Did you know the person, the author of a web design, which we're going to go over later, actually owns that web design? So you want to make sure that that's going to be owned by the company and not the shareholder individually. Can the shareholders compete? Can they solicit business for themselves personally from business clients? How are we going to do if we want to, add shareholders? How are we going to close the business? What if a shareholder wants to sell? What if we need more capital for the business? How is that going to be handled? So the shareholder agreement covers all of those items. And let me tell you, it's so wonderful to have it all in writing, because I have clients who call and they say, we had this issue come up and we don't know how to handle it. And first thing I do is, let's look at the shareholder agreement. Do you have one? Is it signed? Let's read it and see how you handle it. So it's a wonderful roadmap for dealing with all those what-ifs that might come up in business. Now, if you own an LLC versus an S-Corp, it's essentially the same thing, but it's called an operating agreement. This is actually required for all LLCs, whether there's one owner or multiple owners. So it's a combination of the bylaws and shareholder agreement that you get with an S-Corp, and those combine to make the operating agreement. Stock certificates. These are not required in Illinois, but I always do them for all of my clients. It shows you're following the corporate formalities that are required by state statute, so it's a good thing to have. Looks professional, so I highly recommend it. Also, it comes in handy if you're doing like a minority or female-owned business application, because that's one of the items that they ask for is, can you show us your stock certificates? Because they want to make sure that the person who owns the business is a minority or a female. So we use that. So I make sure that everything is in there for clients, especially if they're going to be doing those applications later on. An indemnification agreement. Hang with me on this one, because a lot of people, let me just explain it. So when you incorporate, you get personal liability protection, but only as the owner of the business. So whether you're a shareholder with an S-Corp or a member with an LLC. So it covers you in those instances. If you're like me and you're filling all the roles of your businesses, like for me, I am also president, secretary, and treasurer, and director of my business. Directors and officers are not covered by state law for personal liability. So what an indemnification agreement does is it's a contract between me as director and officer of my business and the corporation, and my corporation is going to protect me if I'm ever sued. So that way, if I'm ever sued, the company is going to cover my expenses, because these days when people are sued, it's kind of a shotgun approach. Even if you didn't do anything personally, they're going to name everyone in a lawsuit, and it does take some money to go to court and say, remove me personally from this lawsuit. It should only be against the business. And we want to make sure that those expenses are covered by the business. So that's what the indemnification agreement does. And that couples with the liability insurance to make sure that that's all paid for. We're going to move on to separating your business from personal. So when you incorporate, and even if you're not incorporated, I really feel this is a good thing for you to do. Every business owner should have separate bank accounts set up and account for everything separately. So if you are incorporated, this is required by law, that everything, whether you're a corporation or an LLC, you have to have separate bank accounts, separate savings accounts if you choose to, separate credit cards. Whether you use QuickBooks or whatever program, it's going to be all accounted for separately. There's a separate tax return for an S-Corp and an LLC. Even if you're not paying income taxes, you're still filing separately. So you want to make sure that everything is set up that way. You don't want to be putting personal money into the business without accounting for it as, shareholder loan or shareholder capital. And you certainly don't want to be taking money out from the business without saying it's payroll or it's a distribution or some other form of money coming out in the proper manner. I feel that even if you're a sole proprietor or a partnership, you should be doing this, because how else, if you don't account for it separately, how are you going to be knowing if you're making money? How are you going to be saying, what are my expenses? How am I going to be growing my business? Unless you're looking at that separately from your personal expenses and income. So this is very important, and it's also the number one way to get rid of that liability protection if you are a corporation or an LLC, because you weren't following this. So very important to do this one. So licensing. This is one that so many people miss. Whether you're incorporated or not, you do need to get, or at least check into, whether you need a business license. So business licensing, there's two separate ones. There's from your village or your city. So say you're in Downers Grove, or you're in your Naperville, you're in a local city. You need to call them and find out if you're required to have a business license. Every village and city has their own requirements. Some only require it once a year. Some do not require it all if you're a home business. Some require it once and done. So it completely depends on the village and the city. Whether you're incorporated or not, you need to check into this. And then there's a state license. So for certain types of businesses, you may need to get a state license. Some that have come up for me are barbers, dentists, cosmetologists, and I have an animal shelter who is a client, and they had to get one from the Department of Agriculture and be inspected. So these are different types of businesses you should look into. You can look up, I have it listed at the bottom, the Illinois Department of Professional Regulation has a list of what the professions require these additional licenses. And then they will redirect you to the correct site, like if you are through a Department of Agriculture or whatnot, for that license. So like for me, for instance, I'm an attorney. I have to go through the Illinois Supreme Court and get one. So that's going to be covering the incorporating process, the proper setup. We're going to go through, if you are incorporated as an S Corp or LLC, we're going to go through annual maintenance. Now this whole presentation is not just for if you're incorporated. We're going to be getting to really great topics later on, so please hang with me. If you're not incorporated, there's still some good information in here coming up for you, especially when we get to the contract section. So maintenance. This is only if you are incorporated as an S Corp or an LLC that you have to do this. So annual reports each year and every year must be filed on time. You do have to do annual minutes. So again, this is just ratifying everything that you've done for the previous year and re-electing yourself as director and officer and catching up on any resolutions. So if you said, oh shoot, I've been incorporated for 5 years and I've never done any of this, it's always better late than never. Get it done. Get yourself caught up. It's important to get it done before that liability arises. So if you're being sued and liability arose and then you go to do it, it might be too late at that point. So always catch up anytime you can. And I always try to get my clients to catch up on their annual report time and say, let's see, what have you done the past year? And let's get those board resolutions done for the past year to get you up to date. So for the annual report, Illinois Secretary of State does require, if you're incorporated or organized as an LLC, that you do an annual report. So it is due on the first day of your anniversary month. So if you're incorporated in May of whatever year, yours is always going to be due May 1st of every year after that. So when you incorporate, those fees are included in the first year, so it's your first anniversary, and every anniversary after that you have to file. So here you can kind of see those differences in prices between the C Corp and the S Corp that I was talking about, as well as the LLC. So C Corp and S Corp is only $100 for the annual filing fee, whereas for an LLC it's $250. The late fee for an S Corp is only $2.50 to $6, depending on how many months you're late, but the LLC late fee is $300. So you can see how it adds up. So at most $106 for an S Corp versus $550 for an LLC. If you are more than 5 months late, the state is going to administratively dissolve your company. So they're going to dissolve it for you, and then you have to pay reinstatement fees. So it's always important to be in on time for liability protection, but for money, do not be more than 5 months late because they will be starting to charge you a lot more fees to get that reinstated. Let's see, liability protection, as I mentioned, with late status, you want to make sure you get it in on time because your liability protection is in serious question if you're late with the annual report. It's different for a corporation and LLC, and any contracts you sign, any claims that may arise during that time could lead to personal liability. So you want to make sure that you get that in on time. You can file it as much as 2 months early. So let's continue on to contracts. So that was annual maintenance. That was short and quick. Important to do, though, for anyone who's incorporated. Contracts, this is important for anyone that is in business. Contracts touches every part of every business, no matter what it is that you're doing. So it goes to liability protection. And these are some types of contracts that you can do. So employment contracts, if you have any type of employees, if you have independent contractors, website policy, so anyone who owns a website needs to have terms and conditions, and anyone who has a website who takes account information or client information through the website also needs to have the privacy policy set up. And then anyone who's in business, you're either in sales or you're in service. So those types of businesses need to have those types of agreements. And then leases. Next to employees, a lease is going to be your biggest expense if you do have one. So it's important. There's a lot of ways to save money and potential liability, but looking at all of the contract terms of a lease. So let's start going through these. So service or sales agreement. Whenever people are coming up with contracts, they're going to be hitting on these topics. You know, what work is going to be performed, how much is it going to cost, who is the customer. You may have a return policy in there. But a lot of people are missing all of these details. So if you are incorporated, you want to make sure that it's your company and not you as the party to the contract. And we'll go over how to sign a contract in a little while. You want to make sure there's some kind of a time frame for finishing. You can't have, it's not a legally enforceable contract if you don't have a time frame in there. So a contract needs to have a beginning and some kind of an end. So I don't know if you've ever seen, like, some of the corporate leases are 99 years. That's why they want them to go on forever, but they have to have an end to be an enforceable contract in Illinois. You want to go over what the responsibilities of both parties are. So say, for instance, in my contract, I provide a service to clients. So, of course, I'm saying everything I'm going to do and how much they're going to pay me, but I also list in there what is expected of the clients. That is a big, big help because if clients aren't giving you what you need to do your work is going to be late, or your work is going to be delayed or impossible to do. So you want to make sure that doesn't look like you're breaching the contract when it's actually the client who is not giving you what you need to do your end. There's going to be payment terms, and late payment terms is a big one. So if a client is late in paying you, how are you going to be collecting that? What about return check fees? All of those types of things. Intellectual property, depending on the type of contract or service you're doing. If you're doing graphic design, logo design, if you're doing websites, you want to make sure who is going to own that intellectual property is listed in there. Indemnification, just like we talked about with the business. So indemnification is if, say, I'm doing graphic design and my client gives me a logo to use, I want to make sure they're going to indemnify me if that logo is infringing on someone's trademark, even though I worked it into my design. And then a big one is you want to make sure you cover the what-ifs. If there is any warranty, if there is no warranty, you do have to disclaim it. And I think the biggest one is a termination. Everybody, it's easy to get into a contract, but how are you going to then get out of that contract? How do you get out, or how does your customer get out of a contract? And then we move to boilerplates. This is like 2 pages that I add to the end of every one of my contracts. And in actuality, no matter all the other things that you have in your contract, it's oftentimes the boilerplate which wins or loses a litigation. So yes, most contracts do not make it to litigation, but if you get there, oftentimes the attorneys can win or lose on what is in the boilerplate, not the actual terms of an agreement. So very important to have that in there. So here we go. How do you sign a contract? So, of course, if you are a sole proprietor, general partnership, you just list your name and you sign it and you're done. But what if you own a corporation or an LLC? You want to make sure that you sign it in this manner, because if you don't, if you just sign your name without listing the company name and your title, it's going to be a personal contract. Even if it's completely for the business, they could hold you personally liable for paying for that. So you want to make sure you list the company name and your name as your title of the company. So whether you're president of a corporation or manager or member of an LLC, you're going to list that way. And now we're going to move on to another topic that we have touched on a little bit, intellectual property. There are 3 different kinds of intellectual property. The main ones that we work with and we interact with as individuals every day are copyright and trademarks. And then there's patents. So copyrights are anything that is written. So you have your books, magazines, websites. There's sound recordings as well. Photos. They also cover a lot of artistic expression, like even works of art or statues, designs, carvings. And then there is trademarks. Those cover 3 types, so company or product name, a slogan, or a logo. And then patents are new and useful inventions or products. So we're going to be going over those. I practice in the area of copyright and trademark law. I do not do patents. So I'm not going to be going over patents today, but let's start with copyrights. So as you can see, it covers all of these types of things people don't realize. So software code actually is copyrightable. Books, of course, are the first thing people think of. Any type of design like a website, photos, lyrics, songs, videos, all of these are copyrightable materials. What works are not protectable under copyright are works that have not been fixed in a tangible form of expression. So anything that's an idea is not covered. Works that are past the protection period, so for instance, if it's been, the protection is for the lifetime of the author plus 70 years. If you're well beyond that, you do not, it's not copyrightable anymore. Works consisting entirely of common property that contain no original authorship. So things that have been around forever, and maybe you're reworking it into a book of quotes, then it is not copyrightable because it's other people's work. And then, like we mentioned, ideas, procedures, concepts, and principles, unless expressed in a written, tangible expression, are also not protected as well. So there are ways that you can use some copyrighted materials without worrying about getting permission. And generally, this is for non-commercial use. It's called fair use. Fair use is not infringement if used for these purposes. So I know you've all seen certain types of shows, like the Daily Show or the news programs. So criticism and parody are not considered copyright infringement. Making comments, news reporting, if used for teaching or scholarship or research, then it is also not considered copyright infringements. And again, these are generally non-commercial purposes. A lot of times I represent a lot of clients who have written a book and they really want to use quotes in the book, but I've had to caution them against doing so because when you're writing a book and selling it, it is for commercial purposes. So you want to make sure that any quotes you're using are past that period where it's copyrighted. So you need to go through kind of this thought process. If it's for commercial purposes, make sure it's expired or get permission of the person who owns the copyright. If it is not for commercial purposes, then you can go ahead and use it. So for instance, on your personal Facebook page, you're not selling it, you're not using it on your business Facebook page, you can generally use the famous quotes. If it's quotes from someone you've interviewed, you do need to get their permission in writing. Whether it is for commercial purposes or not, you really should do this because you're quoting a specific person who is either a friend or a colleague of yours. So did you get their permission in writing? If not, get their permission or don't use it. If you did get their permission in writing, then yes, you can use it. So items to watch out for. These are ones that I have to say kind of surprised me, and you need to get them protected by contract. You have to have them in writing in order to get the copyrights to it. So for instance, say you are writing a book and you're working with another author. That has to be written in contract. Who is going to be getting the copyrights? How are you going to be splitting it? How are you going to be applying for that copyright? If you're using ghostwriters or content writers, you also want to be doing the same thing because the general rule is whoever writes it, whoever creates it, gets to have the copyrights to it. Even if it's someone you hired, you need to make sure you get it in a contract in writing that states it's, and these are the key words, work made for hire. That is what is required from the U.S. Copyright Office to make sure that you own the copyrights and not the author. And the biggest one that surprised me, I have to say, is translations. Even if you wrote the entire book yourself, you own the copyright to a book. If you hire someone to translate it, the person who translates it gets the copyright in that translation, not you, even though you wrote all of the content in your own language. So you really want to make sure that you're thinking about anything, specifically when you're working with books and copyrights, to make sure that you continue to own the copyrights in your own work. So you need to figure out how all of the relationship is going to work and make sure that you have that in writing. So co-authors is an important one to really think through how that relationship is going to work. How it's treated goes to the intent of the co-authors. Do they intend to create one whole work, or are they intending to keep their copyrights separate? For instance, I know a woman who creates compilations, and each chapter is written by a different author. So she wants the copyright to the compilation, but each author gets to retain their copyright in their own chapter. And she has a really good contract that delineates this and works it out so that everyone gets to keep the copyrights that they were intending to keep. So if it is merged into one work, then each co-author is a joint owner of the copyright and can grant non-exclusive licenses to the work, but has to share any money earned with the co-author. So each joint owner may also prepare and publish revisions of the original work, but if a co-owner dies, the interest passes to their heirs and not necessarily to the other co-author. So again, important to really delineate how is this going to work out, because you can avoid the whole heir issue if you have it in writing. The intent may not be readily apparent, and the law doesn't answer all questions, so like whose name goes first on the copyright and on the book, so you need to make sure that we have this all, of course, he's coming back to that contract. We have to have it in writing. So it's best to enter that written agreement before you engage in any serious collaboration. Once you've already engaged and are working on things, of course, if the parties still agree, we can go ahead and do it in writing. It's just a lot easier to do it ahead of time before you've already commingled and worked on that copyrighted material. So what to do if you have a copyright? You're going to put the copyright notice on everything you've created. You want to make sure you tell the world that you've written this or that you've created it and you're claiming a copyright. So you put the copyright notice. Here are some samples of how the copyright notice should look. And then I highly recommend that you further go on and actually file the copyright with the Library of Congress, the U.S. Library of Congress. When you create a copyright, you get what's called common law copyrights. So everyone who creates it or who is an author of a copyright automatically gets common law trademarks or copyrights to it. But when you register a copyright, it gives you a whole other box of benefits. So it provides notice to others, provides notice to the public that you're claiming this copyright. You can file suit to enforce your copyright, which you can't do unless it's registered. It's easier to stop copyright infringement, and you can recover additional damages. So if you are forced to take someone to court, you're able to recover the court costs and attorney's fees if you win that lawsuit because you've gone ahead and registered it. Registering for copyright is not terribly expensive, a couple $100, but it's an important step to protect your rights. So how long does a copyright last? Like we were talking about, use it beyond. If you're going to quote someone, use it beyond the date. So for a regular copyright, it's the life of the author plus 70 years. So I was just talking to another woman this week who was saying she was looking it up, and there's a whole bunch of people you can quote who are beyond these 70 years. Some people are only 10 years away of famous people. So it is out there. Those are safe to use and not worry about copyright infringement unless the estate has filed for further protection. So still need to look at it, but generally those are safe to use. If it's something that's published, it's 95 years from the publication. If the author isn't a natural person, the copyright lasts. So if it was owned by a corporation, the copyright can last as long as 95 or 120 years from creation, whichever expires first. So again, like if you're a corporation and that corporation owns the copyright, it lasts even longer. So another benefit of incorporating. But in general, it's 70 years plus the life of the author is kind of the key dates that you can start looking at those. So we're going to move on to social media and using intellectual property in social media. So there's intellectual property infringement is rampant on social media. So I want to make sure everyone knows how to properly use it. So Facebook, YouTube, Twitter, any of these, you want to make sure that we're using it properly. So social media and copyright. Social media like Facebook, Twitter, and Pinterest allow online posting materials that may be copyrighted. So the site is not going to own, the site does not own the work that has been posted on the site, but the copyright is still owned by the owner. But did you know that by agreeing to post works on the site, you are signing an agreement that gives the site a license to use the work? So though you may own it, just by posting it on Facebook, you're giving, for instance, Facebook, a license to use your work. The license is given without payment. So you really need to read those policies. So here is a sample of Facebook's policy. So you can see you specifically give us the following permission: a non-exclusive, transferable, sub-licensable, royalty-free, meaning it is free, you don't have to pay them, worldwide license to use any intellectual property that you have posted on Facebook. So I know you really want to promote your stuff, but just be careful. If you are trying to protect your intellectual property, your trademarks, your copyrights, anytime you post it on social media, you may be giving up your rights to that to Facebook. So if you do want to protect your intellectual property, the best way to protect it really is to not put it up there in the first place. But of course we need to promote our materials in order to get it out there and shared. So although you own the content, you're going to place these on social media sites, just know that you are granting a license to the media site to use the content and for others to view it. So rules of posting. If you're going to post something, include a copyright notice on your material, so at least you're showing the public. Or if you're posting a picture of your logo in any way or something to your website, post the TM or the registered trademark symbol on your trademarked material. On your website, make sure that you have, again, the copyright notice on the bottom of your website and on your material throughout. Don't just copy materials or photos and repost it. You want to make sure you share the original source material. So if you see that there's a group that you're in and they have content that you want to share, maybe you should go back to the original post and share that instead of sharing it through your group, so that you make sure that the original content is being shared and it's not going through these other people who maybe have been doing the trademark or copyright infringement. And then I personally recommend, and I know people who do social media, it's really hard to do to separate personal and business, but I recommend keeping a separate personal and business page and share differently on each. Because again, if you're sharing for non-commercial purposes, might not be infringement, whereas if you're sharing it on a business page, you maybe want to make sure and be more specific and choose what you want to share on that page because it is for business purposes. If you're using your personal page for business purposes, you really have to be more careful about what it is that you're sharing because it could be considered commercial purposes when you're sharing those items. So food for thought and something to keep in mind. We're going to move on a bit to photos. So here's a picture. I don't know if any of you have seen this, but in 2011, this chimpanzee stole a wildlife photographer's camera and took a selfie. The photographer claimed he owned the copyright, and the U.S. office said no one owns the copyright. Because if you remember, the general rule we discussed is the author or whoever takes a photo is the one who owns the copyrights to that copyrightable material. So in this instance with photos, whoever takes the photo is the one who owns the copyright, regardless of who is in the photo. So this chimpanzee, this was fought in court for a couple of years. It became a very popular photo. First chimp selfie ever. You can imagine it blew up on the social media. And the photographer did not even get to have the rights to this. So keep that in mind. So again, under U.S. law, whoever is the one pushing that shutter button on the camera is the one who is going to own it. So unless there's a written agreement that exists that makes the photo a work made for hire, anyone that you ask to take your picture with the camera is going to own that photo, not you, even if it's taken with your own phone or camera. So what about photos in public? You can take photos in public. This is one that I get a question on this a lot. People are claiming, oh, someone told me that I can't take their photo, that I'm not allowed to take their photo. You can take photos in public. If the public, even on private property, if it's open to the public, you can take photos. For instance, when I go to a private venue, but I'm doing a seminar and the public was invited to that seminar, I can take photos and I can videotape that seminar for my own use. Of course, if someone comes up to me and tells me they don't want their photo, I respect their wishes, and it's good for my brand and it's good for my reputation, and of course for personal reasons, I do not share their photo or I try to get them out of the photo or blur their face. But you do have a right to take those photos in public. If you are in a private setting and it is not open to the public, then you do not have a right to take those photos unless you get permission to do so. So here's a good source for you. Now remember, whoever takes the photo has the rights to those photos, and people are copying photos all the time on Facebook, social media, or grabbing photos off the internet to use for commercial purposes in their brochures, on their website. Just know that that is copyright infringement when you do so. There are myriad of ways that you can get licensed, nice images to be using. Of course, everyone has heard of iStock photos. You do have to pay a small license fee, but you get really beautiful photography, and you get a license to use it. And that's what I use. There are, and even Michelle has pointed out some of these sources to me. She would be a good source to finding a lot of these things because she's introduced me to them. But there's these wonderful sources out there where you can get these, and not only are they royalty-free, but they are actually free for you to use and grab pictures off of. So please keep that in mind, especially when using for commercial purposes. You can't just go and grab images off the internet to use for your own designs. So talking about designs, who owns my design? A lot of people are, again, surprised by this one. There's a lot of myths out there about law, but there's also people don't know what they don't know. And there's a lot to know, especially when you're talking about intellectual property. So again, under U.S. copyright law, the designer automatically owns all rights to the work they do. So all rights and ownership belong to the creator of the work. So if you hire someone to do a logo, if you hire someone to do your website or to do a brochure or to do any type of design, the designer is the one who's going to own it. And this, it has to be in writing. You have to say work made for hire and have it in writing in order to get those copyrights to the materials, which really are yours to begin with. So here are some examples of designs where the graphic artist is the one who's going to be retaining those unless they give it to you in writing. So book covers, that's a big one. If there's a design or a photo on a book cover, the graphic artist is going to own it. Your web developer is going to own your website design. Any photos that are taken, your flyers or brochures, if you have a graphic artist doing business cards or a logo or any type of illustrations, those are going to be owned by them unless it's given to you in writing. So we want to make sure that we get that so that you own your own brand. So for example, if you have a site created by a freelance web designer and there's no agreement in writing, the copyright is going to belong to the web designer according to U.S. laws. So if a year later you want to refresh your site and make some changes through its presentation, freshen it up a little bit, under the U.S. copyright laws, you will need authorization from the web designer and may be required to pay an additional fee to update your own website. So keep that in mind to make sure you get that stuff in writing. So now we're going to switch gears a little bit and talk about trademarks. So copyright, very, very big. Everyone in every form of business is going to be touching copyrights and trademarks. So trademarks is a little bit smaller and focuses more on company or product names, the slogan and logo. So you can see mine are up here. So AMC Legal is my company name. My slogan is serving your legal needs with personal attention. And then here's a copy of my logo. You can see I have my little R on there because I do have it registered. So branding is your company image as seen by the customer. So good branding are going to see an image without your company name and recognize it and associate it with your company. So they're going to be identifying you through that image. So it's good for advertising. It's good for developing your brand. So just like with copyrights, there are common law trademarks and federally registered trademarks. So as soon as you use a trademark, you can claim it as soon as you use it in commerce, which means I put it on my website, put it on my business card, I put it on a brochure, I got the name out there to the public, you can start claiming a common law trademark to it. There's no need to register it, but there are, of course, just like with copyrights, added benefits to doing so. And you can use the TM symbol to show the public that you're claiming trademark rights to one of those items. So if you've ever seen that little TM symbol, or even the SM symbol, because trademark is TM, service mark is SM. So if you've ever seen those symbols, then now you have an idea what that is for. And then just like again with copyrights, you can then register your trademark with the U.S. Patent and Trademark Office in Washington. So it gives the public nationwide notice of the trademark and discourages others from using it. One of the best benefits of federally registering it is it goes into a huge database, and anyone who is out there thinking of a company name or thinking of a logo should be going to that database and looking it up, seeing if someone else is using it. It prevents others from registering your trademark. So if you register it and someone comes after you and wants to register it, you prevent them from using it. And you have the right to sue in federal courts, just like with a copyright, provides more remedies for infringement, and you get reimbursed for attorney fees as well, but only if you have it registered as a registered trademark. So here's the process if you're thinking of filing for a trademark. The very first thing we do is a federal and common law search. So the federal search checks that database that I mentioned. Common law search also checks for people who are using a term but have not registered it. So anyone who's out there who is, so when I do one, we check all 50 states to see if anyone has been using it or filed the company name is using that logo. And then we file the application, assuming you pass that search. We file the application, and then of course we're dealing with the government here, so we're going to wait. There's at least a 3-month waiting period before they even get to look at your application. Once they look at their application, they're going to do their own only federal search. They're going to look only in their database to see if anyone else is using it. If they may have some additional questions, that would be an office action that they send. And then once we get that all cleared, then it gets published in the National Trademark Gazette for 4 weeks. It used to be a published paper. Now it's all electronic, so it's published for 4 weeks every Tuesday. And then you wait 30 days to see if anyone contests your application. And then if they do not, then you receive a certificate. So overall, it takes about 6 months. It could be delayed a little bit if someone contests or if they have an office action, but it takes about 6 months to get that completed. So here are some tips for you. If you have any graphics, software coding done for your business, make sure you get it all up front in writing. I think you've seen this common thread going throughout the entire presentation is get it in writing first. Before you use your business name, please do a trademark search. Even a simple one, a very simple one would be just go on Google, do a domain search, because those are really good kind of leads to let you know if someone else is using it. If the domain name is available, that's a huge hint that it is an available name. If you can't find it on Google, again, a huge hint that it's a clear name. And keep tabs on others who may be using your trademark, whether you filed it or not. Do a Google search every once in a while. Search your logo. You can't really search a logo, but search your name, your product name, search your slogan, and if it pops up from someone else, that's a big red flag to you that someone out there is using it, and maybe you should make sure that you file before they do. So of course, the big thing here, be first to file, because even though you have a common law one, it's a lot harder to file your trademark if someone else has filed before you. Then you have to go and contest it. It can cost you attorney's fees, can cost a lot more and take a lot more time, even if you have rights over someone else. So here are some general contract tips for intellectual property. Make sure you say work made for hire. Your contract has to specifically contain those exact words and clause. Make sure you get all the rights, not just copyrights, but you want to make sure you get all of the rights. So your rights to reproduce, to display, to make adaptations, to get translations. There's a whole list. Your right to disperse everything. Indemnification, if the person you hire infringes on someone else's intellectual property rights without your knowledge, then you're going to make sure that they're liable and not you. So for instance, a big one that comes in with graphic artists. They may think it's original, what they're putting together, but what if it's too close to someone else's and you get sued for trademark infringement? You want to make sure that they're going to indemnify you so that they're liable and not you. Portfolio use. So if you are a graphic designer or someone who comes up with these, you want to make sure you retain the rights for portfolio use so you can show your work and be able to use that without infringing on your client's copyrights. And of course, it must be in writing. Oral contracts are just simply too difficult to prove. You may have come up with many wonderful agreements, but how do you prove it? So again, having all of these details in writings is very important. So now we're going to move on to the CAN-SPAM Act. And again, anyone who sends out an email in business needs to know what this is. So the big difference is this commercial email or is it a non-commercial email communication? So the CAN-SPAM Act covers commercial content. And it's transactional. If it's transactional, it's not going to be covered. So if your client purchased a product from you and you are emailing them to tell them the product ships, that's part of the transaction with the client, and that's not what the CAN-SPAM Act is about. It's really about relationship message that's going to, your relationship and your sales that's going to be covered by CAN-SPAM Act. So again, if it's a relationship message, like if you're emailing an employee, that's not going to be covered by the CAN-SPAM Act. So here are the CAN-SPAM basics. So when you're sending an email, for commercial purposes, and it's not transactional and it's not to an employee, you need to make sure that you follow these rules. So you can't have a false or misleading header information. So what's in the header or what's in the subject heading has to relate to what is actually in the message. You can't have a deceptive subject line either. And here's a big one. You have to identify the message as an ad. Somewhere in the message, they do not say it has to be a certain font. They do not say it has to be at the beginning of the message or at the end. Somewhere in the message, you have to identify it as an advertisement if that is what it is. You need to let the recipients know where you're located. So I know, for instance, and I know Michelle does too, we use MailChimp, and at the bottom of every MailChimp email, you can list your address. So you need to make sure you list your company address in there. You need to let them know how to opt out. Again, if you are sending these emails yourself, you can simply put a line at the bottom, say email us back if you want to opt out of this message. If you use like Constant Contact or MailChimp, those are already included through those services. And that's why I love using them for a myriad of reasons, but that's an additional benefit. It's already done for you if you use those types of services. And of course, promptly honor those opt-out requests. So again, if you're using MailChimp, or if you're using Constant Contact or another similar service, they will do that for you. If you're not and just sending out emails on your own and you get one of those requests, you need to immediately take them off your list and not send another email to them. And you have to monitor what others are doing on your behalf. So if you're using a marketing pro to go and send out these messages for you and they are violating the CAN-SPAM Act, you are held liable. So you need to make sure and check with them that these are all being done on your behalf as well. So here are some best practices for the CAN-SPAM Act. Have the contacts opt in. You're not required to have someone opt in to a mailing list. That's a misconception. You are not required to have someone opt in. But it's a lot better practice. It's a better way. You get better results this way. If you just go around and collect everyone's business card and add them all to your mailing list, you're not going to get good results when you send out emails. You're going to go into their spam. They're going to be deleting them and not reading them. So you want to really make sure you have people who are actually interested in your product getting those emails. You could also be, in the future, blocked from sending those because they're starting to recognize your emails as spam. So again, have contacts opt-in is really a best practice. Using a clear subject line description. If it's not an opt-in list, clearly state that it is advertising. So if someone has opted into your newsletter and they know that they're receiving it, it's not advertising, so you do not have to state that it's advertising. But if someone did not opt in, you do need to state that it's advertising. Include those opt-out options and honor them promptly, and then of course include a physical address at the bottom of your email. So if you do not follow the CAN-SPAM rules, the penalties are ridiculously steep. So it's up to $40,000, $654 fine. You're like, wow, that's a lot. But that's for each email, every single email. So it's potentially, it could be astounding if you are found liable for this. So it's a potential. You could also, in addition to CAN-SPAM Act violations, could be potentially deceptive advertising, and it could be aggravated penalties if it's deceptive advertising, false information, or if you're email harvesting. I'm sure no one on this phone call is doing that, but just know that this is out there, and be careful not to step on any of those. So I hope we've been able to answer a lot of questions, clear up a lot of myths. I do want to say, again, if you found any of this overwhelming, if you're not clear on any of it, or if you have questions on other items, do know that we do offer a free 1-hour consultation. Feel free to give me a call or email me, and we'll be happy to answer any questions you have. Thank you.
This is awesome, Allison. Such great, detailed information, as you said multiple times, which I can appreciate. Very overwhelming for the average person who doesn't have the legal background that you do. And I love the fact that you give a free 1-hour consultation, because not a lot of lawyers do that. And the fact that you do, and you really want to help people think through this stuff, that's a real testament to the kind of care that you do and that you give as an attorney, which your clients often see right away, which is wonderful. So thank you very much. And if the free 1-hour consultation, if people are going to contact you for that, can you show the slide again, the very first slide that has your contact information, so that they can they can see that information and know how to get in touch with you.
Yeah,
There we go.
Yeah, and everyone's situation is unique. So we go through all of these, but you may not know which box you fit in. You know, what's best for my situation. And that's where talking to a lawyer really is the best benefit, because we can kind of listen to what your situation is and figure out the best plan. So I know a lot of this is, even if you're reading and researching, you don't know what applies to you or what you should do. So that's really where the consultation comes in really helpful.
And I think, too, Allison, I know I've sent some people to you in the past, and a lot of times I think people maybe think, oh, my business is too new. Do I really need to talk to an attorney at this point, or when is that point? And you're getting on the phone is always the best way, because you can help them really gauge that and make sure they're protected at the point they need to be.
Yeah, it never hurts to be proactive. I mean, of course, if you're just getting into it and it's more of a hobby, I tell people if it's a hobby, you know, just sit for a little while. But when you start making money or you start relying on that money, you want to make sure you get incorporated and protect yourself. And it never hurts to talk to an attorney before you start so that you know what to expect that's coming down the line.
Yeah, absolutely. And the other cool thing is that, you know, depending on what it is you're doing, that's where the attorney can help you figure it out. I know for me, my big concern was liability when I was coaching clients and things. And so I ended up getting incorporated fairly early on because I wanted to be protected, and I didn't want my family to have trouble if we ran into problems. So that was something I did earlier on in my business than most people often do. And it was costly, but it was worth it, worth every penny, because the cost would have been no comparison if I would have had trouble I had to deal with.
Yeah, exactly.
Yeah, and I know for myself too, like a lot of times I've seen people go through the process themselves and figure I can do this on my own. And for me, I've always had the feeling of I prefer to pay for an attorney to do this. And I know, you know, Allison has done some things for me, and I always prefer that because I never know where the lines cross or they're blurred or how to really interpret something. And so I like knowing that there's someone who gets it that I can just call, and I don't have to spend the time on that, because when I spend the time on that, it takes me away from revenue generating things in my business. And I would much prefer focusing on my genius zone and letting an attorney focus on theirs.
Yeah, that's something that I've come to learn from being in business 10 years is, you know, pay the experts what they do so that you can focus on making, you know, spending the time on what it is that you know and building your own brand and building your own business, and just let the experts take care of it. I stopped doing my own accounting and other things, and yeah, it just helps you grow your business much more when you can focus on the business.
Yeah, absolutely. Well, thank you again for your time and for helping us provide this resource for our friends here at DB Consulting. So have a great rest of your day, Allison. Thank you.
Thank you for having me, Michelle. Have a fabulous day.